Dear participants, a very warm welcome to this lunch webinar. I'm Professor Pascal Pichonnat from the University of Fribourg, and as President of the European Law Institute, it is my great pleasure and privilege to welcome you all. In February 2024, ELI membership has approved the so-called ELI Charter of Fundamental Constitutional Principles of a European Democracy. This is a very important output, and it has been finalized in a time in which issues of fundamental constitutional principles are more important than ever. For those of you who attended already the previous webinars on the topic, you know that the ELI decided to organize a series of webinars to discuss the different parts of this ELI Charter of Fundamental Constitutional Principles. This webinar is already the fifth one. The first one was on liberal democracy, the second on the rule of law, the third on judicial independence, and the fourth on dignity and equality. All these four webinars have been recorded, and the recordings are already available on the ELI website. Today's webinar will have as central topic checks and balances. It is part 4 of the Charter, and it will deal with separation of powers, accountability, open government and transparency, as well as good governance, anti-corruption, and non-state parties. Needless to say that this is very broad, and we won't be able to go into all details for all of these subjects, but nevertheless, I think it will be very interesting. The two co-reporters, Professor Elise Muir and Professor Takis Tridimas, have achieved an incredible work under the chairmanship of Sir Francis Jacobs, first president of the ELI, and Sir Geoffrey Jowell. This project has also benefited from the inputs of internal bodies of the ELI, our scientific director, Professor Christiane Wenderhorst, our executive committee, and the ELI Council, as well as the assessors, advisors, and members of the membership consultative committee. And of course, the project and other parts have been discussed in high-level constitutional law conferences and by various actors at various stages of the process. The final outcome is therefore the result of the individual work of the co-reporters, but benefited also a lot from collective thinking and interactions. In a way, this webinar is a further opportunity to reflect on the impact and the role of checks and balances as fundamental constitutional principles. As always, you will be able to ask your questions thanks to the Q&A function, and we will answer those questions in the Q&A session after the first round of presentations by our very distinguished panelists. So do not hesitate to ask your questions even before the end of the presentation so that we can read them and prepare. Today, we will have the pleasure to have one of the co-reporters who will start, Professor Takis Tridimas. Takis Tridimas is the chair of European law at the Dickinson Poon School of Law, King's College London, and the director of the Center of European Law. He is also professor at Penn State University and a barrister in Matrix Chambers. His interests include constitutional law of the EU, judicial protection, banking and financial law, and comparative law. He is the author of numerous publications, including Schütz and Tridimas' Oxford Principles of European Union Law, Volume 1, on the European Union Legal Order. He will introduce now briefly the Charter first, and then, of course, also part 4 on checks and balances and accountability. Takis, you have the floor.
Thank you very much. Thank you, President. It is, as always, a great pleasure and a privilege to take part in these webinars and indeed to have led this project. Allow me to share my screen, if I may, which I believe it's now done. So what I would like to do, if I may, is first say very few words about the project and then focus on today's topic, which is separation of powers and checks and balances. The idea of the Charter is to provide key principles that encapsulate contemporary European constitutionalism to put under one head, as it were, the sine qua non conditions of liberal democracy. What are the core values? What is the DNA of a European liberal democracy? So I think the overarching themes are three. These are democracy, the rule of law, protection of fundamental rights. And we believe that this project is of added value, even though it largely revisits a well-established territory, and it is of added value for the following reasons. First of all, because there hasn't been a document of this type by an organization such as the European Law Institute, which brings together under one roof principles of governance and principles for the protection of fundamental rights. Secondly, it tries to address contemporary challenges, such as, for example, automated decision-making, protection of the environment and sustainability, anti-corruption. So in that sense, it marries the past, the classic civil liberties discourse, with the future, those areas where traditional principles will need to apply. Thirdly, I think it is commonly acknowledged that liberal democracy is at risk. On the one hand, we have a lot of legislation in Europe over the last 20 years that gives more rights to citizens, but on the other hand, what we do experience is a steady regression in democratic standards, both in emerging democracies, but also in well-established democracies. Various organizations, NGOs, non-profit organizations that use metrics to measure democracy come to the same conclusion, i.e. that there has been regression in democratic standards. And one may disagree with the methodology or specific parts of the methodology, but I think there is consensus that it is a time where we need particular vigilance. So the report needs to be seen in this context. The idea is not to draft a constitution. The idea is to provide some fundamental principles which would need to be adjusted in various constitutional systems. But we look not only at revisiting constitutional principles such as the protection of fundamental rights or judicial independence, but also pointing out some key democratic themes such as the fight against disinformation, anti-corruption, and so on and so forth. So there are 36 principles. These are divided into 7 parts: liberal democracy, the rule of law, judicial independence, checks and balances and accountability, which is today's subject, dignity and equality, protection of fundamental rights, and constitutional integrity. This is the list of the specific principles included. I don't need to go through it. So let me focus on the fourth part, which is checks and balances and accountability, and which includes essentially 6 principles. These are the separation of powers, accountability, open government and transparency, good governance, anti-corruption, and the application of those principles to non-state parties. One word about each of them. Principle 18 addresses the separation of powers. Now, there is consensus that the core aspect of each of the 3 branches of government should be exercised by different bodies. And that is the legislature, the executive, and the judiciary. This is a basic principle of the rule of law. And Principle 18 outlines the functions of each. There are 2 key points here, I think, that we wish to pass through. The first is that the term checks and balances is perhaps a more accurate term than the term separation of powers, because you cannot have in any democratic system a complete separation of powers. The key word here, I think, is interdependence among different branches. And interdependence means mutual respect from each branch to the other. For example, from the judiciary to the legislature. It means circumspection in the interrelationship of the branches, mutual deference and respect. Second aspect, which I think is important, is the limitation on executive rulemaking. This is a specific aspect of the separation of powers, which occupies administrative lawyers and indeed constitutional lawyers, both at national and European level. And we have tried to lay down some principles to limit executive rulemaking, bearing in mind the necessity of it in a modern complex society. Principle 19, the second in this chapter, it has to do with accountability. It stresses that accountability is a key component of democracy. It refers to forms of accountability, political, judicial, and financial. And also in paragraph 3, it takes the view that the core elements of accountability, the core means by which accountability is to be ensured should be provided at a constitutional level rather than at the level of ordinary legislation. Paragraph 4 talks specifically about financial accountability, and paragraph 5 talks about the accountability of the government in relation to military and security services, a difficult area in a democratic society. So accountability is essentially an ex post mechanism. It refers to the obligation to explain and justify conduct. It is a universal principle. It should apply, in other words, to all branches of government. And although I outlined forms of accountability, legal accountability, political accountability, and so on and so forth, the notion of accountability needs to be viewed in a wider perspective. Political accountability does not mean only accountability to the parliament and therefore to the electorate. It means more generally accountability to society at large. It doesn't take place only when citizens vote, but throughout the electoral cycle. Finally, as I said, we included a provision on military and security services accountability. The core idea here is that the direction and supervision of those services must lie with political leadership. Principle 20, open government and transparency. We outline the requirements of open government. These are provided in Principle 20, paragraph 2. The idea is that the executive should exercise public functions as openly as possible, that decision-making at all levels of government should observe the highest possible level of transparency, and also that a consultation is a component that in decision making that safeguards participation and essentially democratic standards. Of course, these are principles, they can be limited, and the third paragraph of Article 20 reiterates that limitations are possible, but the limitations themselves must respect certain limits. So accountability, open government essentially is defined by the OECD as a culture of governance that promotes transparency, integrity, accountability, and stakeholder participation. I think it is both a value on its own right, because it is a component of democracy. It enhances citizen trust. but it is also a utilitarian tool in that it is likely to lead to better decision making. And as I said, our principle tries to encapsulate the dual aspects of open governance, information on the one hand, and consultation on the other. Principle 21, good governance. And this essentially has three components. The first paragraph is an institutional duty, I would say. Public authorities must act fairly and impartially in the public interest. The second paragraph is a duty that falls on political actors and those that exercise public power. And we've tried to define it as comprehensively as possible. The idea is to catch the fact of political life, if you wish. It's not only compliance with the letter of the law, but it is a political culture, the idea of acting honestly, truthfully, avoiding conflict of interests, promoting an environment where these principles are respected. And the third aspect is essentially a corresponding citizen right, which is the right to good administration. So these three aspects that I explained, a general institutional duty, specific duties on decision makers, and corresponding rights for citizens. And the whole idea here, I come back to what I said earlier, there are two aspects. One is that these are values in themselves, but they are also utilitarian. They promote better decision making. One of the themes that we examined looking at this chapter, the drafting committee examined looking at this chapter, is this idea of effective lawmaking. There is a lot of lawmaking in all societies, but there is always an effectiveness gap. To what extent does the law actually fulfill its avowed objectives? And this effectiveness gap may differ from country to country, may differ from area to area, but the point we are trying to make is that open governance, transparency, accountability can reduce the effectiveness gap in lawmaking. Principle 22 is on anti-corruption. One would not necessarily expect to find this in a constitutional text, but the idea is to emphasize that public authorities must fight corruption because it undermines two aspects of the rule of law. First, the equal application of the law to all citizens, and secondly, the prohibition of abuse of power by public authorities. And finally, Principle 23 states that private parties that exercise powers or activities that substantially impact on core elements of a liberal democracy should be subject to constraints which are equivalent to those that apply to public authorities. So this principle essentially recognizes the fusion between public and private power in modern democracies and asserts that equivalent standards of governance should apply to private corporations, private entities that by reason of their mandate, by reason of their power or activities, play a pivotal role in political governance. We have a number of private actors whose activities are closely linked to a democratic life, for example, online platforms, or who are unavoidable trading partners. All of us for good or bad, have to deal with Google or have to deal with Microsoft. And the idea is that those corporations that control access to public space should be subject to equivalent duties. So I think that provides a bird's eye view of this chapter. And I very much look forward to the comments of the panel. Thank you very much.
Thank you very much, Takis, Professor Trilimas, for this overview that helps also to set the scene, so to say, for our next panelists. And I think we will continue without further ado with the issue of separation of powers, or what you call interdependence between powers. And for that, we have the pleasure to greet this afternoon Renate Wits. She's Professor of Law and Government, Royal Holloway, University of London, and Senior Research Fellow. She works at the Democracy Institute, Central European University in Budapest as well. Her major research interests lie in public law and comparative constitutional law, and transition to and from constitutional democracy, the protection of individual autonomy and religious liberty. And her current work focuses on illiberal constitutional practices and the normalization of illiberal constitutionalisms around the world. Her most recent book published is the Routledge Handbook of Illiberalism, co-edited with Andras Saho and Stephen Holmes in 2021. And so we are really thrilled to hear you now on this issue of separation of power or checks and balances. Welcome, Renate Wits.
Thank you very much, Professor Pichon, and for the invitation. It's an absolute pleasure to return to the series of the European Law Institute on the Charter. So let me start without much ado with some comments on the principles of separation of powers, with the understanding that, of course, Principle 18 is very closely linked with the package of principles on judicial independence, and also with the rest of the principles that are in this part. And I thought that what would be useful this afternoon, on the one hand, is a bit of a historical context of how did we land on separation of powers as a feature of constitutional design. And then I would like to take us to some of the challenges, recent challenges, which illiberal actors present to European constitutional democracy. So historically, of course, we can recall the implicit appeal of a tripartite separation. This has deeply ingrained cultural and intellectual appeal. And I think we all remember that when Benjamin Constant was suggesting a fourth moderating power, it didn't quite resonate, especially among European theorists. The other important historic dimension here is that the division of powers was not simply meant as an exercise to increase the efficiency of governance. Historically, this is an effort to stand in the way of the misrule, the abuse of powers, and the tyranny of those who hold public office. Historically, and I'm thinking centuries back, the practical solutions meant to put some temporal constraints to complement those eternal ones, which these kings who were ruling by eternal legitimacy were meant to face in real life, whether this was the White Council of Councillors and later ministers, expectations that the people ruled agreed to taxes, that they can petition these rulers for grievances, and occasionally judges can remind them of natural justice-driven limits to their powers. Now, historically and conceptually, it took a surprisingly long time to move separation of powers from the division of the body politic to different estates, such as the clergy, the nobility, and the commoners, into formalized constitutional constraints. I mean, you should say that the Americans had it easy. They didn't ever have to contend with a king, or at least not for long after the Declaration of Independence. The European script that is taken to be the blueprint for liberal constitutional democracy is the 1831 Belgian Constitution. And in the Belgian Constitution, you see a very strong competition between the unity of powers assigned to the nature, but ultimately held to the nation, but ultimately held by the king on the one hand, and an attempt to try to divide three ways. So when you read the principles in the Belgian Constitution, you will always see that legislative power is something the king dispenses with a legislative assembly. Executive power is with the king, and judicial power is exercised in the name of the king. And fun fact, the Belgian Constitution actually expressly provides that the interpretation of laws in an authoritative manner belongs to the legislative power. It was certainly seen as a way to protect the autonomy of Parliament. Now, historically, European constitutions which follow a parliamentary model very often have a fused executive. Historically, it is understood that it's essentially the peers of ministers in Parliament who are able to accept the type of constitutional accountability and political accountability that Professor Triedemann also mentioned. This mechanism is also maintained in semi-presidential and semi-parliamentary systems. And we often pretend that the constitutional convention that requires ministers to be members of a House of Parliament, which is actually maintained in several countries, has no power dimension. When in real life, the payroll vote of ministers really secures and stabilizes parliamentary majority in several parliaments around Europe. Now, Professor Triedemann mentioned the tendency of the executive to expand its powers, and it's a long-known phenomenon. The sheer size of the civil service and bureaucracy gives the executive extreme weight and competitive advantage when it comes to governing well, but also when it comes to abusing powers. The war on terror resulted in a spectacular expansion of executive powers. It has also resulted in the increase of secrecy that makes both parliamentary scrutiny and judicial control over the exercise of executive powers particularly challenging / non-existent. COVID resulted in yet another expansion of especially executive lawmaking, and these extensions did see judicial deference, this time yielding to the expertise of those civil servants and experts from academia who were informing on particular measures that imposed previously unseen restrictions on civil and political rights. So let me now take you to the liberal context, and I hope to make 3 points. And these points rely on relatively recent developments in the European and global constitutional space. The first is a reminder that the illiberal arrogation of executive powers uses the language of the constitutional infrastructure of respected liberal constitutions. Whether the use flourishes of constitutional identity or the will of the people is secondary. What remains with us is that the script is often familiar from very respected constitutional provisions. And we can see how it takes extremely little to change the balance from checks and balances and this interdependence Professor Triedemann talked about to executive arrogation. Very simply, it can happen through the expansion of term limits in key constitutional offices. Now, this used to be historically a conundrum, mostly addressed in Latin America, But you can see that partly because of a request for some advice from the Secretary General of the Organization of American States, the Venice Commission itself turned its attention into a very detailed report on the constitutional significance of term limits on presidential and other elected offices, including parliamentary offices. The constitutional stakes of the removal of term limits are not very obvious at first, and it's actually in a judgment of the Colombian Constitutional Court when the expansion of term limits was attempted for a second time, when the court made it clear that the expansion of term limits would enable a long-serving president to appoint all key officials that are meant to constrain presidential powers. This awareness of the temporal and personal dimension of constitutional separation of powers remains rare in constitutional adjudication today. My second point about illiberal constitutional actors is, of course, that today, a good decade and a half into democratic backsliding, we appear to have a script of executive power arrogation in plain sight. What has been unimaginable in 15 or 20 years ago is very much part of the constitutional vocabulary today. Russia's exit from the Council of Europe didn't stop the spread of and adoption of these ideas. To use a case in point, I would refer to a piece of legislation adopted in Hungary in December last year that severely restricts foreign funding to any kind of political or civil society activity that could potentially impact the will or thinking of the voters. Now, this Hungarian law is very much modeled on a piece of legislation that was adopted in Russia in 2016. It was an amendment to an already existing foreign agent law. At this time, the European Court of Human Rights already had a case pending before it, challenging the conventionality of the Russian foreign agent legislation. By the time the ECHR's judgment was delivered on the foreign agent legislation, Hungary could have been well aware, and indeed was well aware, that the type of legal rules that they put in place indeed violate human rights standards in Europe. Nonetheless, they decided to go ahead with this piece of legislation, knowing full well that this runs counter to European human rights standards. Not the least because a few years earlier, the Court of Justice of the European Union already ruled against an earlier iteration of a Hungarian law trying to restrict foreign influence in public life. And of course, my third point, which brings me to the relative weakness of supranational constraints on illiberal backsliding in what the European Court of Human Rights likes to call the European public order. The weakness of constraints is not only due to the recalcitrance of illiberal governments, but also to the trepidation and self-restraint of European constitutional actors. Last year, in November, the European Court of Human Rights found inadmissible a claim from 4 Armenian constitutional court judges, one of whom had been earlier a member of the European Court of Human Rights. The judges contested a series of constitutional amendments reforming the composition of the Constitutional Court. The Armenian government engaged with the Venice Commission several times on these amendments, and the last opinion of the Venice Commission made it very clear that they expect to see transitional provisions accompanying these reforms if the reforms were to meet European standards. The reforms without transitional provisions were passed on the very same day when the final version of the Venice Commission's opinion came down. The European Court of Human Rights found the petition of the judges inadmissible because they thought that the lack of access to court was objectively justified in light of a pertinent state interest. The pertinent state interest being the legitimate interest in judicial reforms. The ECHR also said that the applicant judges were not targeted specifically by the reforms. The termination of their office happened through a constitutional amendment. The ECHR ignored that the constitutional reforms went against the advice of the Venice Commission on the request for transitional provisions, and essentially accepted that the legitimate aim of the reforms amounted to a good enough reason to set aside access to justice. Now, the ECHR, of course, can be seen as acting in the spirit of subsidiarity. And this is the point when I would like to call the words of the former president of the court, Robert Spano, who explained that subsidiarity is a defense premised on good faith domestic engagement with convention principles, end of quote. Now, the very fact that the Armenian Amendment was passed on the same day when the Venice Commission advised on transitional arrangements did not appear to cast doubt on the ECHR's trust in the Armenian government's good faith. I doubt I need to say that the ECHR finding a petition from these constitutional judges, among them a former ECHR judge, inadmissible, is not only a legal victory, but it's also a very important political victory for the architects of constitutional reforms that go in the face of the advice of the Venice Commission. So the presumption of good faith, which is situated at the heart of the principle of subsidiarity, appears to accord the benefit of the doubt to populist and illiberal actors in Europe that seek to adopt constitutions to suit their political objective and that shift the horizon of expectations of the European political imagination. This leads me to ask two questions. Only one of them is rhetorical. The first one is, what is the point and the role of particular European constitutional actors in the European public order? And the second one is, who can be reasonably expected and who will put the Charter of Fundamental Constitutional Principles of European democracy to play? Thank you very much for your kind attention.
Thank you very much, Professor Ritz, and also for these very interesting points. And I'm sure we will come back within the Q&A part on some of your points, not only the two last questions, but also on the other aspects, and also the tension between executive and legislative. Executive is quicker in terms of emergency, that may make sense, but at the same time, of course, as you underlined, there's all the legitimacy ground and so on and so forth. So let's continue then our deepening of these principles, and we will now go on principle 19 and 21 on accountability and good governance. And we have the pleasure to have with us Martin Bruzes, and he's been involved in numerous civil society initiatives advocating democracy and good governance in Central and Eastern Europe. His research has focused on the quality of democracy and governance in Central and Eastern Europe, regionalization and Europeanization. In the course of his career, he developed concepts and methodologies guiding the cross-national expert surveys assessing democracy and governance. Martin Bruzes developed as well and advised the EU's Eastern Partnership Civil Society Forum on the Eastern Partnership Index, comparing the progress made by Ukraine and the other Eastern Partnership countries towards EU integration. He has also been engaged in supporting local think tanks to strengthen public accountability, among others, in Montenegro, Ukraine, and Serbia. I think it will be really interesting to see what are your views on this topic of good governance, accountability from this specific perspective. You're welcome. highly welcome, and I give you the floor, Martin Brusis.
Thank you very much, Professor Pichonas, and it's a great honor and pleasure for me to share my thoughts with you and to attend this extremely exciting seminar on a very timely topic. In my comment, I would like to start with discussing accountability by looking at contemporary theories of democracy. I start by endorsing the opening sentence of Principle 19, that accountability is a key component of democracy. It is even possible, I think, to define democracy as a system of government built on accountability. Philipp Schmitter and Terry Lynn Carl have suggested such a definition of democracy, defining democracy as, I quote, a regime or system of government in which rulers are held accountable for their actions in the public domain by citizens acting indirectly through the competition and cooperation of their representatives. This definition differs from your constitutional principle of accountability in three important respects. It identifies citizens as the actors holding rulers accountable. It does not refer to law, and it mentions the public domain as the environment in which rulers are held accountable. In what follows, I will discuss how these three main differences perhaps reflect a different conceptual approach compared to your Principle 19. Firstly, citizens as the ultimate collective authority of democratic accountability are not mentioned in your Principle 19, which is, I assume, due to the fact that Principle 19 is just one of the 36 constitutional principles defining a European democracy, as Professor Trimitas has explained at the beginning. The electorate is covered by Principles 2 and 3 of your Charter, representative democracy and elections. And Principle 19 refers to this electoral accountability by mentioning political accountability. This form is explained in the commentary as a chain of accountability relations running from the people to government. Thus, these references and also the choice to name Principle 19 accountability without a qualifying attribute suggest a broad understanding of the accountability relationship with citizens at the center. However, the other provisions of Principle 19 refer to what Guillermo O'Donnell has called horizontal accountability. This spatial metaphor distinguishes elections, providing vertical accountability, and the checks and balances between branches of government. O'Donnell defines horizontal accountability as, I quote, the existence of state agencies that are legally enabled and empowered and factually willing and able to take actions that span from routine overseeing to criminal sanctions or impeachment in relation to actions or omissions by other agents or agencies of the state that may presumably be qualified as unlawful. Perhaps you have chosen not to use O'Donnell's notion of horizontal as a qualifier for accountability in Principle 19 because the attribute appears to be less intuitively clear for a wider readership. However, by not qualifying accountability, you are also introducing a degree of ambiguity that might lead readers to interpret horizontal accountability as the determining element of accountability. Moreover, Principle 19 might be read as suggesting an equivalence of horizontal and vertical accountability. Perhaps this equivalence might even be recommended to countries undergoing democratization. One could, for example, argue for prioritizing horizontal accountability so as to ensure that newly established democratic institutions perform as designed, and that newly elected post-authoritarian elites discontinue clientelist practices from the past. Yet, such a strategy involves a risk. Weakening or postponing electoral accountability, for example, by delegating powers to non-majoritarian institutions, might erode the political legitimacy of elected governments and trigger a populist backlash, as it is often called. The second difference that you emphasize is that you emphasize the law as a framework guiding accountability. According to paragraph 1, all branches of government and all institutions and bodies that exercise public functions are accountable as provided by law. This sentence basically restates your Principle 7, the rule of law. I assume the term law is used here as a convenient summary concept for three levels of law associated with different accountability procedures and institutions: constitution, laws adopted by the legislature, and lower level regulations issued by public institutions in accordance with authorizing laws. Paragraph 2 of Principle 19 does not specify such a layering of accountability procedures, but it distinguishes between political, judicial, and financial accountability. The non-alphabetical order of these attributes indicates the prioritization to me, with political accountability ranging as the most important form of accountability, followed by judicial and financial accountability. That prioritization is also implied by the commentary, where the political accountability of the executive is labeled as a cornerstone of democracy. However, the commentary does not further explain how the main forms of accountability relate to each other. Are political, legal, and financial accountability different subtypes of a more abstract, general concept of accountability? The commentary does not define accountability expressis verbis, but it does relate accountability to, quote, the obligation to explain and justify conduct. If this obligation constitutes the core concept, the subtypes would specify that concept by adding attributes. There are indications for such a typology, insofar as political accountability is primarily linked to the executive, whereas legal accountability is linked to the judiciary, and financial accountability refers to the public finances. Indeed, it may be possible to include a fourth subtype of accountability, the civilian control of the security sector stipulated in paragraph 4. However, the logic structuring this typology is not very consistent. Political and legal accountability are centered on institutions, whereas financial accountability adds a specific public function. Of the two institutions defining the subtypes, the executive is subject to accountability, while the judiciary's role is to hold other branches of government accountable. There's also some overlap between the different forms. For example, the descriptions of financial and civilian military accountability presuppose functioning legal and political accountability. Let me note that all three forms of accountability feature the possibility of sanctions in the commentary, such as voting against an incumbent government, imposing legal constraints, or disapproving a state budget proposal. The presence of that common feature suggests adding sanctionability as a defining attribute of accountability, which has also been proposed by various theorists of democracy. Are there any other elements common to the various manifestations of accountability covered under Principle 19? This question brings me to my third point. Your wording of Principle 19 does not mention the public domain as a framework of accountability. But the commentary notes, I quote, a wider form of accountability subjecting the actions of government to debate in the public domain. The commentary links this wider form to the principles of liberal democracy and the rule of law defined in the Charter. However, I think the centrality of public debate to accountability suggests giving more emphasis to this feature under Principle 19. Drawing on ideas developed by Robert Goodin, I would like to propose considering discursive or public accountability as a base layer of accountability. On this basic level, accountability requires a rational deliberation that occurs in public. Rational deliberation would expect participants to just claims, consider the common good, respect the viewpoints of others, and aim at mutually acceptable compromises. Rational deliberation underpins what Robert Dahl has termed enlightened understanding among citizens. The knowledge and insights gained from reasoned discourse enables them to make the informed choices that are required for political accountability, which I would then see as the second layer in a nested concept of accountability. Political accountability then provides a framework for parliaments to adopt the laws and state budgets guiding legal and financial accountability mechanisms. A layering implies that defects of accountability at a higher level may be compensated or remedied by functioning accountability at a lower level, but not vice versa. Given this currently a fundamental transformation of the public sphere driven by digital social media platforms. Their business models erode the revenue basis of traditional quality media outlets and foster disinformation, contributing to polarize and fragment the public sphere. Most of the institutions providing public accountability are covered under other principles of the Charter, but I would like to note that the Principle 19 institutions courts, parliaments, budget committees, and audit offices are parts of a broader network of accountability institutions that extend to society and complement each other. Professor Traidenis has also stressed the importance of this interdependence. In my research on democratic backsliding in Central and Eastern Europe, I have included directly elected presidents, independent media, subnational self-governments, and civil society associations as additional accountability facilitating or providing institutions because they can check and balance attempts of governing parliamentary majorities to monopolize power. Accountability emerges from the interplay of these institutions, and I would see these institutions as the elements forming the system of accountability that is mentioned in paragraph 3 of Principle 19. To conclude, what I tried to do was to bring your Charter's Principle 19 in a conversation with current theorists of democracy. I think their insights suggest a way to integrate the different forms of accountability into a more coherent concept based on public deliberation, and to link this concept more to the liberal democracy principles of the Charter. I would like to add a brief comment on Principle 21, that is good governance. Your principle focuses on political representatives and public authorities that are expected to respect three main norms: legality, impartiality, and public integrity. While this wording helps a lot, operationalizing a broad and often diffuse concept, one could consider adding an attribute that reflects the input dimension of governance, such as participation, inclusion, or openness. Such an attribute would strengthen the link between good governance and democracy, suggesting that good governance is most compatible with a democratic political regime. Thank you very much for your attention.
Thank you very much for this fascinating discussion of accountability, the various layers, the structure. And for someone like me who teaches contract law, of course, it's fascinating to see how from this basic principle, one can really create almost a cathedral with such a wonderful aspects that we will discuss again. I was looking for a different word, but okay. Thank you very much, really, for this very interesting discussion, Martin Bruzes. And we will continue because time is running with Michał Krajewski. He's an inquiries officer at the Office of the European Ombudsman in Brussels. He's a member of the strategic team. Previously, he worked as an academic at the University of Maastricht in the Netherlands and the University of Copenhagen in Denmark. He holds a PhD in law from the European University Institute in Florence, in Italy, and he will reflect on Principle 20, open government and transparency. Michał Krajewski, you have the floor. Thank you very much.
Thank you so much for inviting me. So in this short presentation, I will reflect on the wording of the principle and also offer some reflections on how the principles that have been drafted here are already somehow reflected in the practice of the European Ombudsman. So I will just try to theorize maybe this practice a bit more and make it more understandable and confront it with these principles. I will actually start from one sentence in Principle 19, which I find interesting. So, which was already mentioned here. So, Section 2, they are subject to political, judicial, and financial accountability. So, I think the first question is how the Ombudsman fits into this, right? Political accountability in the context of the EU makes us think about the European Parliament and European elections. Judicial, of course, about the Court of Justice. Financial, about both the European Parliament and perhaps also the European Court of Auditors. So where is the Ombudsman here? I found it interesting that in the explanation to Principle 19, instead of judicial accountability, you use the concept of legal accountability. So somehow broader, I think. And then again, thinking about it, I thought that the work of the Ombudsman corresponds to the concept of legal accountability, provided that we understand legal broadly, right? The legal system, as we know, is not only made of rules that are binary, either something is legal or not, it's also made of principles that can be realized to a greater or lesser extent. And I think that when we think about legality review, we immediately think about judicial review and the Court of Justice, and the practice of the court shapes our understanding of what is legality review. But it's interesting that if you consider the remedies that the court can give you, including the European Court of Justice and the General Court, these remedies are somehow binary, right? So it's either annulment or no annulment of act. So either a legal act is legal or not. Same with damages. Either the burden of proof is sufficiently met, so you can get damages, or not. And so this legality in the case of the court is somehow binary because it's shaped by the remedies, by the objective of judicial proceedings. In the case of the ombudsman, the practice is a bit different because the ombudsman doesn't have to be that binary. She can make suggestions to give effect to a specific principle to a greater extent. She can say, in this particular circumstances, an EU institution could have done more to realize, for instance, the principle of open government or making decisions as openly as possible. But I think it's still a sort of an enforcement of legal principles, just in a different method and in a different way than the court. And again, reflecting about that, I've looked through instances of maladministration that the ombudsman identified in recent years in the administrative activities of EU institutions and bodies, because that's the mandate of the ombudsman. And we can see the following category. So maladministration is found if the EU institution or body failed to give full effect to the applicable rules. This can be a regulation 1049 or on access to documents or any other regulations and binding legal rules. Second category would be when a new institution fails to give full effect to their own internal rules. So they promised that they will use their discretion in a specific way in internal rules, but then they did not fully comply with this. But again, the second category is not something specific to the ombudsman because the EU courts do it as well. You can invoke internal administrative rules in the action for annulment, for instance. Third category, when the EU institutions fail to give effect to clear case law of the EU courts. Fourth, when they fail to respect fundamental rights. For instance, we had recent cases regarding equal treatment and discrimination and the rights of persons with disabilities, just to give examples. And five, and that would be probably the broadest category, when the EU institutions and bodies fail to observe standards of good administration. These standards are mentioned in Article 41 of the Charter, but for instance, impartiality and conflict of interest standards. But this category probably is broad because elements of good administrations are not listed in Article 41 comprehensively. So this is sort of the normative source for the ombudsman to expand and develop the understanding of what good administration is and make suggestions based on that to the EU administration. But still, overall, I think that all these categories make us realize that the ombudsman is very much concerned in her work or deals in her work with law and enforcing legal principles in making administrations and suggestions. So I think it's a form of legal accountability, just understood in a different way than judicial accountability. Then one more element from Principle 19, it specifies that the main features of the system of accountability should be safeguarded at the constitutional level. And that's indeed the case in case of the European Ombudsman, because her power to make inquiries are mentioned directly in the Treaty of the Functioning of the European Union. Then this is concretized in a statute, which is a regulation adopted by the European Parliament. And this broad inquiry powers, I think it's the essence of the ombudsman, because we regularly use them. We conduct inquiries by inspecting documents, by requesting written replies from the institutions, but also meeting with the institutions to discuss in depth the subject matter of the inquiry. And another thing, which is again safeguarded at the constitutional level, which I find very important, is the right to complain. So this right is a fundamental right in the Charter of Fundamental Rights. It's also mentioned again in Article 228 of the treaty. And this right is very broad in scope. And I think that's hugely important in the case of the EU, because when you think about the access of individuals to EU institutions, I think it's still relatively limited in a sense that access to courts, as we know, is limited to individual economic operators because of the Plowman criteria and direct individual concern. We do have certain access points like popular legislative initiative, or the right to complain to the Commission about infringements of EU law. But in one way or another, these avenues are somehow limited. So I think that in this regard, right to complain to the ombudsman, which is very broad, because already the first ombudsman understood this as meaning that there are no standing criteria, in a sense that you can bring a complaint in the public interest. So civil society organizations, it would rarely be possible for them to litigate before the Court of Justice, but they can bring complaint to the European Ombudsman. And I think that this is a very important sort of way in which the Ombudsman complements this accountability regime by being this access point for citizens and for civil society organizations. And in fact, again, in recent years, we saw a number of complaints and we conducted a number of inquiries related to issues which would correspond to what is mentioned in Principle 20 about open government and transparency, but also Principle 21 on good governance. Because, for instance, our inquiries concerned how other EU institutions conducted investigations or inquiries, how public consultations on EU policies were conducted, etc. Because another thing to consider, I think that the European Ombudsman is different from national ombudsman in this one respect. So she doesn't deal only with individual cases, although we also have such cases, access to documents or staff cases or individual grants and public procurement, but we deal a lot with issues concerning European governance. So how European Commission conducts impact assessments and holds public consultations, how it uses its implementing powers, and so on and so forth. These are all governance issues, yeah, and these are cases brought usually by civil society. And because of this broad access to the ombudsman, I think that while the EU courts, when they hold EU institutions to account, in the action for annulment at least, they have to very often look from the perspective of their applicants, right? So individual economic operators. Therefore, they ask, or when they control EU legal acts, they ask, haven't the institutions gone too far in regulating, for instance, certain activity or imposing restrictions? The ombudsman very often, because of complaints that we get, looks from the other way. So we're asking, have an institution or an EU body done enough? Could it have done more in this particular situation to realize public interest? For instance, recently, the natural environment and public health. We've seen a number of cases about these issues, or wildlife, for instance. We were asking in these inquiries whether different EU decision-making processes concerning these issues were sufficiently accountable, inclusive, and of course, transparent. But interestingly, we are also trusted by business companies, because we also see complaints brought by business companies that could probably be also brought in appropriate circumstances to the EU courts. And now specifically on Principle 20, it is explicitly inspired by Article 15 of the TFEU, which mentions that decision-making should be as open as possible. And I think that this is what I personally understand as this very important principle that the Ombudsman very often deals with and tries to encourage to comply with or enforce. Openness, so as open as possible, and principle of openness or open government, as Principle 20 says, I think it's much broader than transparency, because it not only requires public access to document or proactive transparency that the Ombudsman encourages, but also it requires the EU institutions and bodies to enable citizens to participate in policy and decision-making and maintain, as again is mentioned in the principle, an open dialogue with representative associations and civil society. And we have recently, we've always received multiple complaints about these issues. So just to give a few examples of our practical work in this regard, for instance, recently we had an inquiry concerning the public consultation on the Sustainable Corporate Governance Initiative. This policy initiative, encourages companies to manage sustainability issues better in their operations. And the Ombudsman found in this inquiry that the Commission did not report all the content of responses received through online campaign platforms. And the Ombudsman noted that in this way, the Commission could, for the future, discourage organizations from launching similar campaigns and participating in public consultations. The explanation to Principle 20 mentioned also that all relevant groups should be consulted and all responses should be duly considered. And of course, in practice, it is not easy to verify whether this has been the case in the practice of EU institutions, because you have a number of questions. Should the proportions of different stakeholders should be perfectly equal, civil society and the business, for instance. How to actually verify that an institution has duly considered all the voices. Also, should the institution be required to respond to all substantive concerns of the groups that participate in the dialogue or open consultations? For instance, recently we have dealt with an interesting case in this regard. It concerned the Commission initiative concerning new genomic techniques, plants produced with new genomic techniques, genetically modified plants. And the complainants, which was a civil society organization, they were concerned that certain substantive scientific concerns that they were for a long time bringing to the attention of the Commission were not sufficiently addressed. And I think that this case is very interesting because during the inquiry, the Ombudsman used her inquiry powers to, in fact, enable the dialogue. So this open dialogue, which you mentioned in Article 20, we asked first for a written reply to the complainant, then we met with the relevant department of the Commission to further explain to us certain concerns that the complainant have. We drafted a report, we shared it with the complainant, and then we summarized everything in our closing decision. And for instance, I see this case as the Ombudsman instrumental to enabling this open dialogue also with civil society that you mentioned with Article 20. And for the future, in this case, the Ombudsman suggested that the EU institutions should not only say that they have taken concerns into consideration, but they should explain more openly how, right? So I think that this is this open dialogue in practice. And last but not least, I would like to mention one more element from Principle 20. So I think it is very important that the Principle 20 mentions that decision-making process at all levels of government must observe the highest possible level of transparency. I mean, in case of the European Ombudsman, of course, transparency is the usual suspect. 1/3 of our inquiries concern public access to EU documents, and we still see that there is a lot of work to be done in this field. But I would like to mention one recent initiative that kind of shows why this principle is important and how it further should be realized at the EU level. So according to Regulation 1049, there should be a particularly high standard of transparency with regard to EU legislative documents. And in recent years, the Ombudsman has received a number of complaints precisely on legislative documents. So last year, we have decided to open an own initiative inquiry addressing all three biggest EU institutions, so the Council, the Commission, and the Parliament, and share with us a sample of public access requests concerning legislative documents. We just received them, and the inquiry is ongoing. So we want to obtain a fuller picture of the actual access and whether indeed we have a particularly high level of transparency with regard to EU legislative documents as mandated by the EU treaties and the principle that you drafted. So I hope this gives some interesting views on the principles that you drafted and also a snapshot of the Ombudsman's activity. So thank you for giving me an opportunity to present this, and I will be happy to respond to any questions. Thank you.
Thank you very much, Dr. Michał Krajewski. I think that was very valuable to see also how things in practice are set into motion, and also to have an insight into the, as you said, European Ombudsman sitting in Brussels, but trying really to be this enabler of a dialogue that helps also to improve the accountability on certain levels. As time is going on, we come now to yet another broad subject, and Principle 22 and anti-corruption. And we have the pleasure to have with us Yves van den Berg. He has been the Belgian European prosecutor at the European Public Prosecutor's Office, the so-called EPPO in Luxembourg, since 2020. Prior to that, he was Advocate General at the Court of Appeal in Ghent in Belgium. In that capacity, he was for almost 6 years Deputy Chief of the Cabinet of the Ministry of Justice for Criminal Procedural Law. And before that, he was also a Deputy Public Prosecutor at the Public Prosecutor's Office in the Tribunal of First Instance in Dendermonde, where he dealt with criminal cases in financial matters and organized crime. He is and was speaker in several seminars about criminal law and published in The Matter, of course, and so to say, he's also a specialist of anti-corruption. And so I'm really thrilled to listen to what he has to say about the interaction or the potential of Principle 22 and the issue of anti-corruption. You have the floor, Yves van den Berg.
Thank you, Professor. It's a special honor for me as a European prosecutor to convey to you my views on the importance of fighting corruption and establishing anti-corruption policies with a view to protecting the democracy and the rule of law in Europe and beyond. As you have said, I'm the Belgian European prosecutor at the central level of the EPPO. We are almost 3 years operational. The European Public Prosecutor's Office is a supranational judicial body within the European Union. It is a real and classic public prosecutor's office that investigates, prosecutes, and brings to judgment the perpetrators of crimes affecting the financial interest of the European Union. The EPPO, I think, is quite unique in Europe and even in the world in the sense that as one single office, it exercises its competences and prosecutions powers directly in several EU member states. Now 22, very soon in 24 EU member states, because also Poland and Sweden will join us. The material competence extends to crimes affecting the financial interests of the European Union. This covers EU expenditure fraud, fraud with funds, subsidies and procurement, and EU revenue fraud, such as VAT carousels and customs fraud. Of course, that includes corruption and misappropriation by public officials. At the end of 2023, we conducted nearly 2,000 criminal financial investigations in the EPPO member states. Of course, financial investigations including corruption, with an estimated total damage of more than 19 billion euro, and 1/4 of our cases has a cross-border dimension. I can fully agree with all the principles are accurately described in the Charter of Fundamental Constitutional Principles of a European Democracy. Congratulations to you who drafted and approved the text. As public prosecutors dealing with criminal investigations and prosecutions, we must fully respect, of course, the rules and the principles described and imposed by your charter. Many of these relate directly to the work of a magistrate, judge, but also a public prosecutor. Hence, I want to emphasize this not only for judges as described in the charter, but equally for magistrates of the Public Prosecutor's Office. For instance, of course, rule of law, proportionality, independency and impartiality, the protection of fundamental rights for suspects and victims during the investigation phase and prosecution. Perhaps I can say, and not perhaps, but for sure, that Principle 22 states that public authorities must take effective measures to prevent and fight corruption. Fighting corruption is for law enforcement authorities, prosecutors' offices, and of course, at the end, for judges. Corruption poses serious threats to the security and financial interests of liberal democracies. It not only undermines, in my opinion, state institutions and weakens the democracy and the rule of law, but it also harms citizens' social, financial, and even physical security. Yes, also the physical security. Let me give you an example. You all remember the head-on collision occurred between two trains in the Tempe Valley in Greece on the 28th of February 2023. In the accident, at least 57 people were killed. the passenger train and the freight train were traveling in opposite directions, but ended up on the same track. Already 4 months before, on 28th of November 22, the Greek office of the European Public Prosecutor's Office started to investigate the contracts for restoring remote traffic control and signaling system on the Greek rail network. For the moment, there are charges of financial fraud and corruption against 23 suspects, including 18 public officials, for crimes relating to the execution of contracts for restoring remote traffic control and signaling systems on the Greek rail network, co-funded by the EU. That's why we are competent as EPPO. It's crystal clear, dear audience, that liberal democracies should adopt all measures necessary to fight and eradicate corruption. Principle 22 is therefore fully justified. The establishment of an independent body provided with oversight and enforcement powers in the field of anti-corruption is key to the effectiveness of anti-corruption policies. In my opinion, the EPPO, like most of the National Prosecutor's Office, fully comply with that. The EU EPPO regulation and the PIF directive of 2017 provides the EPPO with the necessary powers, investigating tools, and enhanced cooperation in cross-border cases. At EU level, as you have described in your charter, Regulation 2020-2092 on a general regime of conditionality for the protection of the EU Union budget is a key instrument in the fight against corruption. This regulation requires appropriate measures, such as suspension of payments or commitments, to be taken where rule of law breaches affect or seriously risk affecting the principles of sound financial management or the protection of the financial interests of the Union. But another very important and recent initiative is the European Commission's proposal for a new directive on combating corruption, including the amendment of the PIF direction of 2017. PIF stands for Protection des Intérêts Financiers. This is a part of the anti-corruption package that was adopted by the EU Commission in May 23. The focus of the proposed new directive is threefold, and it complies very good with your principle 22. First of all, the proposed directive aims to consolidate existing anti-corruption rules into one single legal act. It does so by harmonizing the definition of corruption offenses as per the UNCAC, discovers bribery, misappropriation, trading in influence, abuse of functions, obstructions of justice, and illicit enrichment related to corruption offenses. The proposal also approximates the common minimum level of criminal sanctions for both individuals, but also for legal persons, as well as for aggravating and mitigating circumstances. Secondly, the proposal includes measures for the prevention of corruption, which member states should adopt in order to build an effective system for integrity systems. These measures consist in awareness raising campaigns, research and education programs taken to mitigate incentives for corruption. The aim is to ensure that the public sector is made accountable. So the principle of accountability, as described by previous speakers. As a consequence, member states are to establish qualitative transparency through access to information of public interest, the declaration of possible conflicts of interests, asset declaration systems for public officials, and frame contracts between the private and the public sectors. Thirdly, the proposal from 23 from the EU Commission is to facilitate the effective investigation and prosecution of corruption cases. competent law enforcement agencies, services, as well as prosecuting and investigative entities should thus be properly resourced and able to use dedicated investigative tools like interception of communication, assets recovery, infiltration observations, pre-trial detention, and so on. This also covers the adoption of minimum rules on the statute of limitations, notably, of course, to prevent foreclosure in complex cases requiring lengthy investigations. Lastly, the proposal also addresses the misuse of privileges and immunity when aimed to prevent criminal investigations. I strongly believe that all these measures can contribute to the principles and needs of protecting liberal democracy as perfectly described in the Charter of the European Law Institute. Thank you for your attention.
Thank you very much, Ivan den Berger, for this insight also in the almost everyday work of the EPPO and the consequences of anti-corruption work to be a foundational aspect also of this charter. We have not much time available for some questions. And so what I suggest is we got a couple of questions. I'm not sure we can discuss all the questions until the end of this webinar, but I will at least pick one or two that I think might also bring some light of some aspect that were mentioned. And one, maybe I begin with the last one. Sorry for those who were quicker, but the last one is dealing with Principle 18 on the separation of powers, and is the following: does also the judicial power on its side require control of balancing checks by other branches of government, or is it a principle that judiciary is a merely self-restrained branch of power? And you mentioned this interdependence, but also we had this issue about dialogue and accountability. So I thought that this principle or this question by Oliver Marder may also bring in some interesting aspects. So I don't know whether Takis, you want to answer first, or maybe Renata Jutz, you want also to react on that question.
I'm excuse me. I am happy to say a word. First of all, many thanks to all panelists. That's been enormously interesting and important comments. So I very much welcome the insights that were provided by Mr. Kraveski, by Mr. van den Berger, on how these principles relate to the work of the institutions. And I'm also enormously grateful to the comments made by the other commentators with the critique. If I can say, and I'm not going to say anything else, if I can just take 3 points. Starting with the first, the question that was put by Dr. Marder, and I think it's extremely important. And my answer to that would be yes. I think that the principle of separation of powers, the principle of interdependence and checks and balances also applies to the judiciary. And I think it's sometimes we tend to over-rely on the judiciary to provide these accountability controls. Sometimes we tend to forget how difficult it is to bring the judiciary into account. For example, in the context of the European Union, the most effective way of controlling the European Court of Justice, I would say, is the national courts themselves. It would be very difficult for the member states or the political institutions of the European Union to take steps against the Court of Justice. Any such step would require a lot of time to be introduced. It would require political consensus, but the key to the integration door is the cooperation of national courts. If the national courts stopped cooperating, then that would be enormously detrimental. And that just shows that the most effective control on the European judiciary is actually another branch of the judiciary. So yes, I think the judiciary should also be subject, but I would also ring a bell of caution here, because it's one thing to disagree with judgments. I often disagree with judgments, and that's of course part of the discourse. What I object to is when the critique against the judges becomes a critique of legitimacy, because part of the rule of law regression is to attack the legitimacy of the courts. And it's one thing to disagree with a judgment, one thing to try and improve the exercise of judicial function from the outside. It's another thing to undermine the judiciary as an institution of governance. Two very quick responses to comments. Where does the ombudsman fit in accountability? Yes, it is part of legal accountability. One could identify other forms of accountability, like performance accountability. So in an auditing universe, as it were, one would identify different forms of accountability, and it would be a lot more detailed. But yes, interesting reflection. Yes, it is part of the legal accountability. In the principle, we focused on judicial accountability because it is the main form in terms of constitution. A final comment on what Mr. Bruce said, which was an extremely interesting critique. Should we have focused more on the on societal and citizen accountability? This is very interesting. I think this partly reflects, I would say, the composition of the drafting group. It was not a it was not in any way an attempt to undermine or place less reliance on the citizen as being the central forum of accountability. But I take the point. Thank you.
Thank you very much, Professor Tridimas. Professor Uyts, I just wanted to maybe, not directly that question, of course, but I was just wondering about this backsliding. You mentioned backsliding of the illegitimacy and so on. The question is probably, on the one hand, you have the independence of the judiciary, and then you have the accountability. And how do you see potential backsliding in the illegitimate powers? Because you said basically the framework does not always change, but slight changes may put everything in a real danger. And so I was just wondering, maybe as a last point, this interrelation between independence of the judiciary and accountability, how you would look at that.
Thank you very much for this question. Of course, as Professor Tridimas mentioned, judicial accountability is a bit of a hairy concept, especially when it's weaponized in order to cleanse the judiciary from unwanted element. And the difficulty that both the Venice Commission and the European courts face is to on the one hand, ensure the proper quality of judicial judgments, the proper manner in which, say, case files are processed, so the simple amount, the docket management of courts and judges is done properly. These are administrative concerns. Without measures that go into criticizing judicial performance, say excess of proceedings, turning into a political vendetta against ordinary judges and also the constitutional court. So here you have a range of international principles, including the Bangalore principles, that are extremely helpful. And it takes me back to the comment I made earlier, that at the moment, the presumption of subsidiarity, the principle of subsidiarity is taken to be based on the presumption of good faith. And the supranational bodies, both the courts and the Venice Commission, just needs to take this presumption with a grain of sought when it faces judicial reforms that seem to pursue an ulterior motive. So I would leave it here. If you need a constitution that constitutionalized judicial accountability, this was used in the 2010 Constitution of Kenya, and there is plenty of misuse and abuse of the principle in political practice that counsels against over-enthusiasm about constitutionalizing accountability at the expense of judicial independence and impartiality.
Thank you very much. I think that's very useful, very interesting. I see that the bell is ringing because we get to an end of the time allotted to this webinar, unfortunately, because of course on all various aspects there would be a lot to discuss, but we took also note of the various comments that were written on the Q&A section, and maybe that could be used for future discussion as well. My duty, but my pleasure, is really to thank all the wonderful panelists of today's webinar, because I think it was really interesting, as mentioned by Professor Takis Tridimas, how the reflections between practice and theory in a way merged into this part and this webinar in a beautiful way to open and to create relations between different principles in a way that made a lot of sense. So thank you very much to all of you. Thank you also for all people who attended this webinar. We will have 2 further webinars in this series on fundamental principles. The next one will be on the protection of fundamental rights, and then we will have a 7th one on constitutional integrity. You will have all the information, you had all the information in the chat, and we will, of course, continue to make publicity for these webinars. Thank you very much. I wish you all a wonderful week. Thank you for attending. Thank you for being wonderful panelists. Goodbye and see you soon. Bye-bye.
Thank you.
Bye.
Thank you.
Thank you. Bye.